All right, let's review what we've learned about exculpation clauses. Remember what this is about, and I have the provisions up here from Delaware law and the Revised Model Business Corporation Act. A corporation may put in its articles of incorporation a provision that exculpates directors for the breaches of their fiduciary duties. In other words, if I breach my fiduciary duty, the articles of incorporation say that I will not be liable to the corporation for money damages. Now, we remember the limitations on that in both Delaware and the Revised Model Business Corporation Act, that you can only exculpate for breaches of the duty of care. You can't exculpate for breaches of the duty of loyalty, breaches of the duty of good faith, breaches of the duty to monitor, and you can't exculpate for waste. And you may not exculpate executive officers. The articles of incorporation may only exculpate directors for breaches of their duty of care. Let's talk about the history of the exculpation clause, because it's very interesting. Before there was a provision in Delaware law, the Revised Model Business Corporation Act, allowing a corporation to exculpate directors in its articles of incorporation, we had a case called Smith v. Van Gorkum. And it's a case of TransUnion is going to be engaged in a merger, and the board of directors of TransUnion were not real careful about their decision-making process and their information gathering. And the Delaware Supreme Court said that the board of directors of TransUnion breached their duty of care. They acted in a reckless or grossly negligent manner. They were engaged in a grossly negligent decision-making process. Now, this had never happened before. The Delaware Supreme Court had never found that the board of directors of a public corporation had breached their duty of care. And so this was a surprise to everyone. It took everyone off guard, and it meant that the board of directors was liable for monetary damages, and they were unhappy about this. So the public companies and their law firms, etc., lobbied the Delaware legislature to change the law. And the Delaware legislature changed the law. They added Delaware Business Corporation Act, section 102B7, and that's the section that we have been looking at. This allows a corporation to put in its articles of incorporation a provision that exculpates directors for breaches of their duty of care. Now the question becomes is that are directors protected too much? With the exculpation clause, there is no liability for directors for breaching their duty of care. If you're a director, you breach your duty of care, and your corporation has the 102B7 exculpation clause, then you get away scot-free. Is this too much protection for directors? Well, the argument is that this is what shareholders want. We protect the directors so that they are not afraid to take appropriate business risk, that when they take some sort of business risk, that they will not be second-guessed and possibly the court getting it wrong and holding them liable because they took appropriate risk, and in the end, the transaction failed, the company lost a lot of money. Well, that's looking at it in hindsight. If we look at it ex ante, did they take appropriate business risk? And we're worried that the court is going to get it wrong. So the exculpation clause is arguably something that the shareholders want. It is good for them because the corporation needs to take risk. Without risk, the corporation is not going to make any money. Now, a couple things you have to remember about the exculpation clause, or the most important thing you have to remember about the exculpation clause, is that it's optional. A corporation does not have to put this in its articles of incorporation. And remember, when a corporation amends its articles of incorporation, it has to get shareholder approval. So if this is presented to the shareholders as an amendment to the articles of incorporation, well, then the shareholders can reject it, saying, no, this is not what we want. Now, there are other circumstances where we have a company that has been set up a long time ago with the exculpation clause as a closely held company, as a private company, and then it goes public and it sells shares to the public. At that time, the investors, the new shareholders who are now investing in the company for the first time, cannot reject an amendment to the Articles of Incorporation, because as they are investing in the company, the Articles of Incorporation already have this provision. But they can protect themselves by either saying, I'm not going to invest in a corporation that has this exculpation clause in its Articles of Incorporation, or I'll invest in it, but I'm willing to invest less because it's not giving me the protection I want. So the argument that it protects shareholders is tested through these two mechanisms that come about because the provision in the Articles of Incorporation, exculpating directors, is optional.